It goes quiet for a while and then it comes back. And we've got some really interesting things that we have found out now that we actually have the motion to quash, the affidavits. Why are they subpoenaing Bethany Funk? What do they want to know? Which side's subpoenaing her? What are their reasons for trying to quash this subpoena? And we discussed a lot of options this morning, and we've gotten some answers, but some still to be discussed. A bunch of you tagged me in Brian Etten's tweets. We're going to look at some of the documents he posted. Azam sent me some of the documents. Sleuthy sent me some of the documents. So I have quite a few documents to go through and just kind of explain how we got here. Kim also sent me this shirt. I did a quick wardrobe change since this morning's video, just because this was sitting on my desk because it got mailed to me over the weekend. So that was always fun. A new golf shirt and a vest and some ball markers when I hit it on the green. So that's always fun. We also hit 219,000 subscribers. And I saw Azam post about this. 2 lives in one day, always fun. 220 by the end of the month. Azam, I think we can get it by the end of the week. If you guys hit subscribe right now, if literally everybody that just watches this video hits subscribe, then I think we can hit 220K by the end of the week. And we are on the road to 250K. It's wild. It's fun. Every milestone seems unattainable until we attain it. And it's just kind of cool and fun. So I appreciate you guys doing that. Hit the like button if you haven't already so that people can get some answers, because you all had a lot of questions about what was going on. And I said on Twitter that this was a subpoena from the defense to Bethany Funk. And you all correctly pointed out, absolutely correct in pointing out that we don't know who subpoenaed Bethany Funk. And that's fair. And I think that when you pointed that out, I backtracked and said, we'll see who subpoenaed Bethany Funk. I assumed it was the defense because of the motion to quash, just the way the docket kind of set up. We know now it was the defense, but I didn't know at the time, right? And I was just, Azam said, the end of the month is the end of the week. Good point. But I was just assuming based on kind of the way the filings were going, and it turned out that that is what happened. So we're going to get into it. And we're going to get into first what they attached with the subpoena. I have a bunch of different documents here. I'm going to try to show you the ones that are the best quality. Some of them are not the best quality, which is why we're going to try to use Brian Etten's tweet. I think that has some of the better quality documents on here. But let's first get to this. Nope. Already off to a rip-roaring start. That's the motion to quash. We're going to wait on that. Here we go. Let's start with this. This is the request for a foreign subpoena, out-of-state commission. The witness is Bethany Grace Funk. Affirmation pursuant to NRS 239B. Undersigned, affirms the preceding document does not contain the social security number of any person. Who filed this? Evelyn Grosnick, one of the attorneys we looked into earlier this morning. That is a public defender in Nevada, where the witness is, not where Brian Kohberger is. So she is basically, I don't want to say helping out Brian Kohberger, but the public defender offices are working together to get this out-of-state subpoena done. She does not represent Bethany Funk. We talked about this earlier. We didn't know which subpoena did what. I'm sorry, which lawyer did what. All right, here's the index of exhibits, and here's exhibit 1. And this is where I'm going to actually hop over to Brian Etten's tweet, because I think the document is a little clearer, hopefully for you guys. And we're going to start with the magistrate judge. Having considered the defendant's ex parte motion for certificate to secure the attendance of an out-of-state witness and the affidavit of Richard Bethany, Bitanti, We'll try that again when it comes up for his affidavit. In support of said motion, the court being otherwise fully advised herein, here is what Megan Marshall says. She is a magistrate judge for the 2nd Judicial District of the state of Idaho, which is a constitutionally and statutorily prescribed court of record in the state of Idaho. And just FYI, I have not read every word of these. I've skimmed some of them. So we are going to read every word together and react here and, of course, answer your questions. In this case, Brian Kohberger is charged with 4 counts of first-degree murder under Idaho Code 184003, which is punishable by death or by imprisonment for life, and 1 count of burglary under Idaho Code 181401, which is punishable by imprisonment in the state prison for not less than 1 and not more than 10 years. I am the judge assigned to preside over the preliminary hearing that's scheduled to occur on June 26, 2023 through June 30th, 2023. Bethany Funke may, and that's an important word when we come back to the motion to quash, may be a material witness for the defendant in this case. So that answers one of our big questions. Who called her? Why are they calling her? Does Brian Kohberger think she is going to be helpful for him? I just noticed something. All right. Paragraph 5. For the reasons stated in the affidavit of Richard Bethany, I don't know why I'm struggling with that, the presence of Bethany Funke, and we're going to get to that affidavit, the presence of Bethany Funke is required at the Latah County Courthouse, located at 522 South Adams Street, Moscow, Idaho, beginning at 8 a.m. on June 28th, 2023. That is a specific time. Under the laws of the state of Idaho, if Bethany Funke comes into this state in obedience of a summons requiring her presence at this hearing, she will not be subject to arrest or service of any process relating to matters that arose before she entered the state under the summons. So, already had some questions about paragraph 6, and I apologize. I left it small there. I will blow it back up and make it big as we continue to read. But paragraph 6, I'll let you take a look at it now. What does this mean? Does this mean that there is a warrant out for her arrest, that she committed crimes prior to this subpoena being entered? Sleuthy sent me some messages about this as well on Twitter. Is this boilerplate? Is this common? The answer is yes. This is very common. They put this in when you subpoena somebody from out of state, forcing them to show up, because we do not want to dupe people or have aha, gotcha moments when they show up in our state because we need them to be a witness in a case, and then say, oh, there's an open warrant for your arrest for something you did 2 years ago. Now that we've got you here, we're going to arrest you, and we brought you here under these false pretenses or under something else. So we don't want that to happen. We want people to be able to come in when they are material witnesses under certain circumstances from one state to another to testify. And we don't want to create problems by arresting people when they show up. Now, you may think that, well, that's unfair. If they committed a crime in my state and they left and my state can't reach out and bring them back, they should get arrested if they step foot in the state. Well, that creates other constitutional issues and privacy rights and issues that each individual has from state to state. Certain states can extradite you and bring you in for certain crimes. Other ones can't. So we don't want to have that be an issue when we need somebody to come and be a material witness in a case that has nothing to do with some other warrant they may have. We talked about Fifth Amendment, how that can come into play on this morning's video. So if you want to check that out, feel free. All right, page 2. This certificate is made for the express purpose of being presented to a judge of a court of record in the state of Nevada in support of an order to compel the attendance of Bethany Funke at the time and place, and for the reasons stated above. This is a judge certifying she must show up. And if you're wondering, why go through all this? Why do we have to have this affidavit? Why does the judge have to say these certain things and these certain buzzwords? Well, because there are rules. And if you miss any rules, there will be a motion to quash filed. We're not there yet. Because first, we are going to get Bethany. Okay. All right. So ex parte motion for certificate to secure the attendance of an out-of-state witness comes now. Brian C. Koberger, buying through his attorney Ann Taylor, public defender, and hereby moves this court for a certificate to assist in securing the attendance of Bethany Funke as a witness on behalf of the defendant in this case. This motion is based on Idaho Code 193004, 193005, 19852, and the attached affidavit in support of the motion for out-of-state service. So they have to ask the court for help in going and getting this out-of-state witness to secure her and make sure her presence, that she is at the preliminary hearing. That's what they are trying to do. All right. So let's take a look at Bethany Richard. Let's look at Richard's affidavit here. I am a criminal investigator hired by the defense to assist in the representation of Brian Koberger. Making sure it's still on the screen. I was asked by appointed counsel Ann C. Taylor to investigate the alleged incident which led to the arrest of Brian Koberger. Brian is charged with 4 counts of first-degree murder, 1 count of burglary. The deaths took place in a 3-story home. There are 2 bedrooms on each floor, bathrooms on each floor, and a kitchen, dining, and living room on the middle floor. Mr. Koberger is alleged to have entered the house around 4 a.m. while 6 people were sleeping/present, killing 4 people in 2 separate rooms. The people killed were located in 2 bedrooms, one on the 2nd floor and the other on the 3rd floor. Bethany Funke's bedroom was on the 1st floor. The other surviving roommate's bedroom was on the 2nd floor. Bethany Funke was interviewed by police on several occasions. So we're going to pause here on paragraph 9. Bethany Funke, people are saying make it bigger. This is as big as I can do it because I'm looking at it through Twitter. This is the best version. Trust me, I have other versions that are harder to read. So I'm reading it out loud to you. So hopefully that'll help too. So paragraph 9, where we are going to focus for a minute. Bethany Funke was interviewed by police on several occasions. She disclosed things she heard and things she saw. So what does that mean and why is it important? Number 1, she spoke to police multiple times, gave them multiple statements, it seems. Yet her statements were barely mentioned, if at all. I really can't remember much that they gave about BF or Bethany Funke in the probable cause affidavit. That's number 1. Number 2, there are statements she made, so they are not guessing at what she would or could have stated or testified. There are actually statements. So they have a good faith basis to say she is a material witness that can testify about this. Okay? Now, paragraph 10. Bethany Funke was present at the home 8 hours later when police were called, arrived on scene, and discovered the homicide. So they mentioned the police weren't called until 8 hours later. Will her testimony have something to do with that? What happened in those 8 hours? Paragraph 11, we're going to focus here for a second. During the course of my investigation, the private investigator hired by Ann Taylor for Brian Koberger, it became known to me that Bethany Funke has information material to the charges against Mr. Koberger. Portions of information Miss Funke has is exculpatory to the defendant. That means could prove his innocence, could prove he did not do it. We have seen that Brady or Giglio evidence has been turned over to Ann Taylor. Was it Bethany Funke's statement? Was it her testimony? We don't know. Additionally, the last sentence in paragraph 11 is incredibly important for what we're talking about. Miss Funke's information is unique to her experiences and cannot be provided by other witnesses or by another witness. So again, relating back to the discussions we had this morning, and you all had some really, really great questions. Can't they just get it done with other witnesses? Why do they need her? Well, according to the defense, she is the only one that can state the testimony that they need or that exists in this situation. So while it may be a hardship, and we're not trying to harass or make anything more difficult on these victims, because they're not alleged victims, right? They are victims. Bryan Kohberger allegedly did these things because it hasn't been proven. But the things happened, right? We know what happened. And the victims are victims, regardless of if Bryan Kohberger did it or somebody else. So we always want to respect that and protect them. But if they have something that could be exculpatory, I will just tell you, we're going to read this motion to quash. There are going to be parts I agree with and parts I vehemently disagree with. So let's read the last paragraph here first. Bethany Funke, and I will point out, Funke is missing the E on the end, resides in the state of Nevada, and it is necessary to subpoena this witness because the witness's testimony is material and necessary to this case. They did misspell her name there. That's where I noticed it. It may have been other places. We're about to hear them called out for that. Because now we're going to get to, let me see here. The motion to quash. This was filed by Kelly Ann Valoria. We looked her up earlier, former prosecutor for 14 years, now family law lawyer in Nevada. All right, so actually, before we get to the motion to quash, I see some questions are coming through. So let me go through some comments and questions here. Lisa Alana and Wendy Phillips and Lee Olson are some new members. Patrick Mott. Hey, Peter and Lawyer, you know, fam, been super busy this month. Missed y'all. Well, Patrick, I'm glad you're back. When is jury selection, et cetera, supposed to start, Pat? So on June 26th, I think it was, through the 30th, is the preliminary hearing. While people are calling it a mini trial, it is not a jury trial. We did an entire video explaining what a preliminary hearing is. It's basically to prove they have enough to continue forward on the charges against Bryan Kohberger. It's not beyond a reasonable doubt. We talked through all of that before. So there will be no jury selection. The trial does not start on June 26th. Just the preliminary hearing does. Lil Patty. Peter, what does quash mean exactly? It means to basically get rid of this subpoena. It usually means it's done wrong, something on it's done wrong. It can also be because it's harassing or there's no legitimate reason. They're just trying to bother this witness. It can be something similar to a protective order, but usually if there's a mental health reason or some physical reason that she cannot show up or she needs to be protected and not have to come testify, that usually is better served with a protective order, not a motion to quash, but sometimes they can sound similar. We're going to get to why they filed the motion to quash in this case here in a minute. John O'Rourke, it's been a minute. Was she eating DoorDash? I don't know what her testimony is at this point. Henry, if a defendant were to confess to their lawyer, is the lawyer required to pass the message forward? No. Or is it like doctor confidentiality? It would be privileged at that point. Ashley, shouldn't all interview recordings be shared with the defense? Yes. But just because they have the police interview doesn't mean they wouldn't want to call her as a witness. All right, let's get to this motion to quash here. Motion to quash foreign subpoena. Foreign just means from another state. Comes now. Kelly Ann Valoria, counsel for Bethany Funke, with an E, and respectfully moves to quash the foreign subpoena the out-of-state commission obtained by Evelyn Grosenick interim Washoe County public defender. Oh, so she is the public defender there, interim, on behalf of the defendant, Brian C. Koberger, for a preliminary hearing in this case. This motion is made and based upon the attached points and authorities, all papers and pleadings on file herein, and any evidence and argument to be heard on the matter. This was just filed on Friday. All right, so let's get to the memo and points and authorities. Sorry, I didn't realize the comment was still up there. Facts. That's facts. On April 3rd, 2023, Evelyn Grosnick, interim Washoe, I'm sure I'm pronouncing that wrong, county public defender, sought and obtained an ex parte foreign subpoena, which was issued on April 11th, 2023, that purports to require Bethany Grace Funke to appear in the 2nd Judicial District Court of the state of Idaho, county of Latah, on June 28, 2023 at 8 a.m. for the duration of the trial or when released by the court to testify in the above named case. The items provided in support of the subpoena were an ex parte request for foreign subpoena, out-of-state commission, which contained the following: certificate of an Idaho judge to secure the attendance of an out-of-state witness, which we read together, the ex parte motion for the certificate to secure the attendance of an out-of-state witness, which we read together, and an affidavit in support of the motion for an out-of-state service, which we read together. That was the private investigator. The affidavit in support of the motion for out-of-state service further claims that Miss Funke, if you're going to call other people out for typos, right? Probably shouldn't make typos of your own. That's why I don't usually like to call people out for typos unless they are material, because she says who name is repeatedly misspelled. We did see at least one spot where it was misspelled. Has information material to the charges against Mr. Koberger. Portions of information Ms. Funke has is exculpatory to the defendant. These statements are conclusory, without support, and there is no further information or detail pertaining to the substance of the testimony, its materiality, or the alleged exculpatory information of Ms. Funke, or why it would be entertained at a preliminary hearing. Moreover, the subpoena was issued by the clerk of the court without hearing. No hearing has been set for Ms. Funke to address these concerns. This motion follows. So, again, there are going to be portions of this I absolutely agree with. There are going to be portions of this I don't agree with. All right. The court should quash the foreign subpoena issued purporting to compel Ms. Funke's attendance at the Idaho preliminary hearing in this case. She states some rules govern the issues of a subpoena in criminal court. Some more rules govern the procedure for securing the attendance of the witness for testimony outside the state. Excuse me. This rule in particular addresses the process for summoning of a Nevada witness to testify in another state. Specifically, this rule requires the court to fix a time and place for a hearing before it can issue any order directing testimony in another state. This hearing is necessary to provide a venue where the judge determines that the witness is material and necessary, that it will not cause undue hardship to the witness to be compelled and to attend and testify in the prosecution or a grand jury investigation in the other state, and that the laws of the state in which the prosecution is pending or a grand jury investigation has commenced or is about to commence, and of any other state through which the witness may be required to pass by ordinary course of travel. So, what is she saying here? She is saying that a hearing has to happen. Regardless of if everything else makes sense, regardless if this is true, a hearing has to happen, and the hearing didn't happen. If she's right, then they're going to have to do the hearing, and they'll have to pause this and stay it until they do the hearing. But many times, affidavits, especially signed off under oath by a judge, can make another jurisdiction waive hearing. So we'll see if that becomes a reason why they stay this. It's not going to be a reason they quash it and it just goes away. It would just be delaying the inevitable. Once that procedure is followed and that burden is met, then and only then shall the judge issue a summons with a copy of the certificate attached, directing the witness to attend and testify in the court where the prosecution is pending or where a grand jury investigation has commenced or is about to commence at a time and place specified in the summons. In any such hearing, the certificate shall be prima facie evidence of all the facts stated therein. Moreover, there is no authority for an Idaho criminal defendant to summon a Nevada witness to Idaho for a preliminary hearing. This is where we get into some interesting discussion about definitions and whether a deposition and a trial and a grand jury proceeding are different than a preliminary hearing. There is no authority for an Idaho criminal defendant to summon a Nevada witness to an Idaho matter without a hearing. Okay, so we may have to have a hearing. And there is no authority to summon a Nevada witness to an Idaho matter without a Nevada judge making a finding of materiality, necessity, and lack of undue hardship. So is what she going to say important, meaning material? Is it absolutely necessary, or can they get it somewhere else? And is it going to be nearly impossible or incredibly hard for her to show up and do this? The Nevada rule does contemplate a Nevada criminal defendant's ability to subpoena a witness to appear before a court in Nevada. However, there is also a requirement for a hearing. Thus, even if the law applied by analysis, no hearing occurred and that important procedural requirement was not met. Additionally, the rule provides that if a judge of a court of record in any state, which by its laws has made provision to commanding persons within that state to attend and testify in this state, certifies under the seal of such court that there is a criminal prosecution pending in such court, or that a grand jury investigation has commenced or is about to commence, that a person being within this state is a material witness in such prosecution or grand jury investigation, and that the person's presence will be required for a specified number of days, upon which presentation of such certificate to any judge of a court of record in the county in which such a person is, such judge shall fix a time and place for a hearing and shall make an order directing the witness to appear at a time and a place certain for the hearing. Okay, a lot of words basically saying you have to specify when they have to show up and how long they have to be there again, so that it's not an undue hardship. Importantly here, there is no certification by any judge of any court of record in any state, Nevada or Idaho, that clearly, that's a big word, clearly states that Bethany Grace Funke is a material witness in such a prosecution or grand jury investigation. So what do they mean? Well, if we hop back to the judge's statement here, that paragraph 4, Bethany Funke may be a material witness for the defense, may be a material witness. What page was I on here? Here, at the bottom of page 3, no judge clearly states that she is a material witness. So maybe a material witness, she's saying the rule says they have to say she is a material witness. Maybe that's something they'll argue about. Additionally, this is for a preliminary hearing. The rule says a prosecution or grand jury investigation. This is something that I think they are going to have a hearing on, and they're going to have to determine, is she a material witness? And is a preliminary hearing, does that fit into the same box as a prosecution or grand jury investigation? And this almost makes me laugh. I know we're talking serious matters here, but this is why lawyers at 5 o'clock today, I have a rules committee meeting with the Florida Bar Civil Rules section. We have had no less than 20 meetings on a less than 5 paragraph rule, that we are going over every rule and how it can be argued and how it should be defined. This is what happens. So, is a preliminary hearing the same thing? All right, a close reading of the certification purported to be from a judge, it sounds like it's from a judge, merely states that Ms. Funk may be a material witness. This is insufficient under the law for this foreign subpoena to stand. And that is why we need to have a hearing. And that's what I agree with here in this motion to quash. I think we need to have a hearing to answer some of these questions. Lastly, as this court is well aware, a preliminary hearing is limited to a finding of probable cause. And this paragraph, maybe the next two paragraphs, I can't remember, are where I vehemently, strongly, ardently disagree. Okay? I love when, I judge, I respectfully disagree. I forcefully object to this, judge. I like when lawyers do that. I've done it myself. As this court is well aware, a preliminary hearing is limited to a finding of probable cause rather than reasonable doubt. That is correct. Which is the evidentiary burden at trial. I agree with line number 1 and 2. That is correct. This is the same standard in both Idaho and Nevada. This case specifically holds that a preliminary hearing is not a substitute for trial, and the purpose of a preliminary hearing is to determine whether a public offense has been committed and whether there is sufficient cause to believe that the accused committed it. So sufficient cause, not beyond a reasonable doubt. A preliminary hearing is not meant to become a mini trial due to its limited purpose in deciding a probable cause. Okay, I misspoke. This is not the paragraph I disagree with. I agree, absolutely agree with this paragraph. Here's the paragraph I disagree with. Arguably, then, even if Miss Funk possesses exculpatory evidence, which remains unknown, there is no place or reason to present that evidence at a preliminary hearing. Let's pause here for a minute. Let's pause here. I'm going to read it again, and then we're going to talk about it. Arguably, then, even if Miss Funk possesses exculpatory evidence, so we're saying, assume she possesses exculpatory evidence. Even then, there's no place for that to be presented at a preliminary hearing. Here's where I disagree with that. Okay? And for this analysis, it does not matter if Bethany Funk possesses exculpatory evidence. Let's just move that out of our mind, and let's live in a world right now where Bethany Funk possesses some piece of evidence that says it is not Brian Kohberger, which it doesn't have to go to that level to be exculpatory, right? But if she does possess that evidence, and if they present that evidence at a preliminary hearing, and I'm a judge, or you're a judge, or this magistrate's the judge, and somebody presents evidence that proves Brian Kohberger didn't do it, that by definition would prevent the state from proving that there is sufficient cause or probable cause that Brian Kohberger, in fact, committed this public offense. That is the exact kind of evidence that should be presented at a preliminary hearing. Come on. Come on. We can't do that. We can't do that to people that say, even if they have good evidence, judge, come on, we're not going to present a preliminary hearing. We know the defendants always lose preliminary hearings. It's like, no. And I will tell you, this is strange to me. It is weird to me that there is a victim who was at the house when the crime was committed in the 8 hours between the time it happened and the call to 911. And she was not, I'll just say, not highlighted in the probable cause affidavit and not going to be called as a witness by the state at the preliminary hearing. And that the defense would go as far as to try to subpoena her and force her appearance and testimony at a preliminary hearing, knowing that regardless of what her evidence is, it's not like she's going to be friendly to the defense. She is not going to be a friendly witness who wants to show up and help Brian Kohberger out. It's strange. So I really disagree that assuming she has exculpatory evidence, that there's no place for that in a preliminary hearing. A preliminary hearing requires the state to offer competent evidence to support probable cause and convince the magistrate that a trial should be held, not the issue of innocence or guilt of the defendant. I totally disagree. Because if the defendant can prove innocence at the preliminary hearing, then the state cannot present enough evidence to support probable cause. It literally stops the state from being able to do what they need to do at that preliminary hearing. You would think if there was evidence to prove innocence, the state would drop the charges. So I'm not saying that evidence exists. But if it did exist and the state still refused to drop charges, that's why we have this layer of protection. This should not just be going through the motions. This should not just be a rubber stamp. This should be another part of the process where we make sure they have enough, because guess what? So, I mean, this just boggles my mind, because if they have evidence to prove Bryan Kohberger is innocent and we don't present it at the preliminary hearing, Bryan Kohberger just sits in prison while everybody continues to think that he did it. Everybody says he did it. Everybody expects that he's going to be convicted. And then later at trial, oh, we have this evidence that proves he's innocent. Okay, not guilty. See you, Bryan Kohberger. Sorry for the misunderstanding. It's like, no. This is exactly the time it should be presented to the state and tell them, hey, drop the charges. But just because the defense attorney says, hey, we have this, we think it's exculpatory, doesn't mean the state's going to agree. But this is another opportunity to present it to an unbiased person, meaning a judge. They don't have to agree. They can say, nope, there's enough for probable cause. But if you have it, you absolutely should be able to present it. Exculpatory evidence is an issue for trial, which the documents presented misleadingly suggest the preliminary hearing to be. Some strong words here, about spelling her name wrong and misleading the court and having no place for this kind of evidence that I just disagree with. For all of the reasons the subpoena served upon Ms. Funke is improper. Accordingly, the court should quash the subpoena issued purporting to compel Ms. Funke's attendance at the preliminary hearing in this case. So what I would say is that last paragraph seems a little disingenuous. And, I don't like to go at lawyers, as you guys know. So I'm not. She is probably a very good lawyer, and she's fighting hard for her client, as she should, zealously representing her client. But what I would say is, at the very least, what the court's going to do is order a hearing. It's very unlikely that they just quash the subpoena outright. Or if they do, it will be refiled to correct the misspellings and ask for a hearing. In conclusion, the foreign subpoena was improperly issued because there was no hearing. There was no component of the statutes followed in issuing it, and the court should quash the subpoena issued to Ms. Funke now. So that is the motion to quash. Interesting to me. All right, let's get to some of your questions. Kathy Trout, Nevada, put emphasis. Oh my goodness. So now people are telling me I'm pronouncing Nevada wrong. That could just be a Florida accent at this point, okay? Certain things I know I pronounce wrong. I'm going to stick with my Nevada pronunciation. That's how everybody here says it. Put emphasis on the second syllable, Nevada. Pronounce it so that the middle part rhymes with ad. Nevada. Oh, Nevada. That's what you're saying. Nevada. Nevada. I don't know about that one. Crystal, question. Is it not true then if a client says they did it to their lawyer hands are tied and how they can defend? There are certain things you can't lie. You can't perpetuate a fraud, but you can still force the state to prove your client did it beyond a reasonable doubt. Every lawyer has different philosophy. Okay. Some lawyers will still point out other possible people that could have done it. I would take a totally different strategy. Usually when clients admit that they did it, we try to work out a deal. But it is not unethical to still go to trial and say the state still can't prove that your client did it, even if they admitted to you that they did it. Mr. RN, which one of the reasons I don't practice criminal law anymore, it's getting to some nuances there and it can get a little hairy. Can she appear via video? What should the state do? It's a great question. We have Zoom nowadays. Can we just do it by Zoom? I think that sounds like a pretty good alternative, especially for a preliminary hearing. Now, sometimes lawyers think, oh no, I got to get her in person. I got to look her in the eye. We got to be able to see if she's telling the truth or not. I think for a jury, there may be a good argument for that. For a judge, I think the judge can look at her on Zoom and get everything she needs to get. Glenna, they can't lie in a probable cause affidavit, can they? No, they're not supposed to. RVing, keep it rolling. Yes, cops can lie in a probable cause affidavit. I disagree. Cops are never allowed to lie. Let me back that up. For investigative techniques while questioning certain witnesses, they can tell lies during that process, right? That they admit our lies and they'll tell you our lies at the time. They can't lie to the court. They cannot lie in a probable cause affidavit in order to get a warrant. That would be a fraud on the court. And they would absolutely be reprimanded for that. And it could potentially be a criminal act. Lou Garou, what are the chances the subpoena will be quashed? I don't think the subpoena is going to be quashed, but I think they may have a hearing and determine, is it appropriate for a preliminary hearing versus a trial or a grand jury proceeding? And can they do it by Zoom or something else? And is she a material witness? That was the other one. Is she actually a material witness? I think the answer is yes. Azam, what's the difference between a witness and a material witness? So, great question, Azam. If you needed a witness to say that the house that all this happened in was built in 1972 and it was built with thin walls, so it is possible people heard things through different walls. That actually may be material. But something that you don't necessarily absolutely need to prove the crime. Something that's exculpatory is absolutely material to this case. Material just means absolutely important versus you still want to call somebody. I mean, you could argue everybody's a material witness, but certain witnesses are not as material. Let's say, and again, you could argue it's material, but records custodians. Yes, this is a record for this office. This is how they keep their records. This is how we print them. This is why we put the page numbers on the bottom right. This is who signs it. That person's an important witness, but they're not necessarily material to proving exactly what happened. So material is just something that's very important. John O'Rourke, I got lost. So are they or are they not bringing all the evidence in at the preliminary hearing? I think all the evidence should be brought in the prelims. They do not have to bring all the evidence in. They have to bring enough evidence, whatever evidence they believe is enough to prove that there is sufficient cause to move forward on these charges against Bryan Kohberger. That can be a lot, that can be a little, but they better make sure they bring enough as the state in making the decision to what they're going to present to the judge. And if the defense can prove innocence, then no evidence is going to be enough to prove probable cause, right? Leah MT, just to speculate, if BK is exonerated, would he have any grounds for lawsuits against the media outlets spreading misinfo, rumors, etc., or is that just par for the course these days? So I don't know. I haven't listened to every news outlet. I'm kind of shocked that some of the news outlets that are getting sued and making payments and doing all this stuff with all these cases and trials that are going on. Back in the day, I feel like the news was kind of untouchable. Media was kind of untouchable. Maybe that's not the case anymore, which I think is a good thing. But he would have to still prove the elements of defamation and things like that. Slander. Was it false? Did they know it was false? If you're falsely accused and arrested, I shouldn't say falsely. If you're accused and arrested and tried and not guilty or exonerated, you don't automatically have claims because this is the exact reason why. Because there is enough evidence. Law enforcement, a judge, prosecutors all felt there was enough evidence to arrest you and charge you with this crime. So they believe it to be true at this point. Now, if Bethany Funke says, I took the picture of a guy, he was a 5'2", I'll use Murdoch's example. He's a 5'2" guy that committed this crime. There's no way it could be Kohberger. here's the evidence, and they ignored that evidence and kept going forward, then potentially he could have some claims. But if she just says, oh, I knew Brian Kohberger, he was harmless, and that's good evidence and maybe exculpatory, may not, there are still decisions to be made and discretion to be had. And there was still enough because of his DNA, because of his whereabouts, because of his pinging on his cell phone in his car to arrest him. He's not really going to have a claim just because he was exonerated or found to be not guilty. You don't automatically have a claim. There has to be some wrongdoing and something that other people did. We've had those cases. We've represented criminal defendants who were wrongfully accused, and law enforcement totally disregarded evidence that proved their innocence. And there are successful claims in those situations, but not always. Why be so nosy? Could the information she has impeach the 3 probable cause affidavit the police wrote? Possibly, but I don't think that I'm feeling that's where this is going. Thus throwing everything out. Thanks for covering this. I think it's going to be more like people came in and out of the house at all hours. I didn't think anything of it. We didn't even know anything was wrong. We don't know everybody's friends. I think it's more stuff like that. That kind of disproves that Kohberger's the only guy that could have possibly been walking through the house at that moment. I think it's something more like that versus, we're positive he didn't do it. Terry Dice, so could we still have a killer out there? I mean, he's presumed innocent, so it's still possible. I don't want to fearmonger or say something like that or spread that, but it's still possible at this point. Stephen Rode, law enforcement and the prosecutors do not believe so. Does double jeopardy exist for PH? PH. I'm not positive who PH is. Probably not the best term, but essentially one chance and one chance only to move to the next. Preliminary hearing. So no, that goes in with like the statute of limitations. They can still gather more evidence, and if they present it enough, they can still move forward on charges as long as within the statute of limitations. Now, if we talk about it's outside the speedy preliminary hearing rule and things like that, we can see. But you don't want to swing and miss because it could create major problems, and the state could then use some of that at future proceedings and tell the judge, oh, they just came up with this extra stuff, and that could help them poke holes if they don't bring it the first time around. Squab Bob. Toby Cat, could it just be for Bethany to say, no, I didn't see BK there that night? Absolutely. Absolutely. Somebody who was there. And now she may say I was asleep, but maybe she wasn't asleep. Maybe she was up making pizza. Maybe she ordered a DoorDash. It could absolutely be something that simple. Ellen, I don't think media has changed. I think access to information has changed. Okay. Well, let me know what you guys think in the comments about that. All right. Yeah, I talked about this a little bit this morning. Pair that with the Brady Giglio and the math ain't mathin'. So we'll see. All right. So that's the end of this video, part 2 of this motion to quash and all of these additional affidavits. I appreciate everybody joining me, especially let me know if you were here for the doubleheader in the comments. Hit that subscribe button. I want to hit 220,000 by the end of the week. If you guys will join us on this ride, hit that notification bell so you don't miss anything that we've done on this case or the other cases. I appreciate you all joining me. Kind of fun. Day opened up and we were able to hang out twice. So hit that like button, hit that subscribe button, and we'll be back together soon. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.